Hi, everybody. Thank you for joining, and I think we'll still have some people filtering in for the next minute, but I want to make sure we have plenty of time for our panel to talk. Really quickly, my name is Sean Vitka. I'm the director of the Fourth Amendment Advisory Committee. Could I get a quick show of hands? Who's seen one of our events before? And I know at least one other person. So mostly new folks, and that's awesome. That's good news. We will be holding more of these events over the course of the year, and we're always trying to be a resource, connecting staff on the Hill with experts, especially experts who aren't on the Hill and who you may not otherwise hear from. So on that note, we have a team of awesome experts here. Marcy Wheeler, who was supposed to be here in person, is currently experiencing a wind apocalypse out in Michigan. And I can tell you that we tried to figure out every other way to get her here. She was not able, but it seems that this, I'm going to call it Big Brother style situation, thematically appropriate, works pretty well. So she can hear us, she can see us a little bit. I'm going to have all of us, and when we get to Q&A, I'm going to encourage you to speak as loud as possible to make sure that she can hear you. But I may be on my phone a little bit, making sure she hears clearly, and I promise it's not because I'm not paying attention. So, with that, we're here to talk about Section 215 of the PATRIOT Act, and this is most likely going to be the biggest surveillance reform fight of this year. In 2001, when the PATRIOT Act was first being debated, there was a controversy over a provision known as the library records provision, and that was criticized by people on the outside for providing the FBI with the ability to effectively subpoena library records. And so you can actually look at this, and if you just type into Google library records provision, you will see that that was one of the biggest issues with the PATRIOT Act when it passed. Fast forward 12 years, and it would turn out that that is the same provision that allowed the government, according to the government, to collect all telephone metadata records on a prospective basis across America. So that's called the telephone metadata dragnet. We're going to be talking about what we know now, what we know since the last reform and debate around Section 215. But the reason this is so important for you and your bosses to start thinking about now is that at the end of 2019, on December 15th, there will be another sunset of Section 215, which is the primary opportunity for Congress to jump in and consider whether it should be reauthorized, and if so, how it should be modified. I'm going to jump over and start with Alex. Alex, would you please introduce yourself and tell us a little bit about Section 215 in a historical context setting way?
Sure. Thanks for having me, Sean. My name is Alex Abdo, and I'm a senior staff attorney at the Knight First Amendment Institute at Columbia University. And as relevant here, I used to work at the ACLU for some time litigating questions relating to NSA surveillance, including the program that we're talking about today. So, historically, Section 215 had very modest origins. It was originally a kind of little-noticed provision of FISA enacted in 1998 that gave the FBI very narrow authority to compel a short list of companies to turn over a very short list of records relating to a very short list of people, mainly agents of a foreign power. But in 2001, it was amended by Section 215 of the PATRIOT Act, and now everyone calls that provision Section 215. And it expanded along essentially every one of those axes. It became a general authority for the FBI to get an order from the Foreign Intelligence Surveillance Court compelling anyone to turn over any tangible thing relevant to an authorized investigation. So it was no longer limited in terms of who could be targeted, what sorts of records could be subpoenaed, or the kind of nature of the investigative interest was expanded to any relevant thing rather than records relating to an agent of a foreign power. And as Sean mentioned, in the early days, there was this concern that it would be used to subpoena library records. And that concern, in retrospect, seems impossibly quaint. Because it turned out in secret, the government had interpreted, along with the Foreign Intelligence Surveillance Court, the authority of Section 215 extremely broadly. And there was reason for concern that there would be a kind of strange interpretation of 215, and people were focused on it in the early years after its enactment. But we were also told at the same time that it had hardly, if ever, been used by the government, at least in the first 5 years or so after the enactment of the PATRIOT Act. But then around 2010, I think it was, but someone can correct me if I'm wrong, I think it was around 2010 that Senator Wyden started issuing ominous warnings about a secret interpretation of Section 215 that the government had been relying upon, that when the public learned of, they'd be shocked and stunned. And we learned what that interpretation was on June 5th of 2013, which is when reporters working with documents obtained from Edward Snowden first disclosed the existence of the NSA's telephone metadata program, or the call records program. And under that program, the NSA had been for years compelling major telecommunications providers in the country to turn over on an ongoing daily basis all of the call record data of their users, their customers. So who they called, when they called, how long they spoke, and it seems at least general information about where they may have been. All of that was being turned over as early, I think, as 2006, I believe, is when the program was first moved under Section 215. So for those 7 or so years. After that, a kind of lengthy legal battle ensued that resulted in the USA Freedom Act, which was the first major effort at reforming FISA, or Section 215 in particular, since 1978, which was when the nation's intelligence surveillance laws were first enacted. So that's the kind of historical perspective. Is that what I should cover, Sean? Okay.
Give us a sense of scope, right? So
Yeah.
I think it's easy to say they're trying to collect all phone records, but what does that really mean in terms of impact?
So what the NSA was doing is they would issue these orders. Each order lasted for 90 days, and they would issue them recurrently to major telecommunications providers to obtain all the call records of these communications providers' users. They would store them in a centralized database that they would then query when they had an interest in records in the database for the phone numbers associated with their targets. So if I were a target of this program, although I couldn't be because the program was limited to non-US persons, but if I were a target of this person, of the NSA at the time, then they would query the database for using my phone record, and they would obtain all of my call records, all of the call records of my contacts, and in some cases, all of the call records of my contacts' contacts. So they'd go out 3 hops from their target and obtain an enormous swath of information, which they would then shunt off into another database where they would conduct more sophisticated technical analysis. We still don't actually know the details of the analysis they conducted. We know something about it. We know they engaged in something called contact chaining, and I think we know some other details, but we still don't know the full breadth of the technical analysis the NSA was conducting on these records.
Thank you, Alex. So we're going to have Alex talk a little bit more about court cases that he's personally litigated. You really can't ask for a better expert on these issues than the people you've got here, not including myself. But before we jump into some of the more, let's say, appellate-style cases about Section 215, Marcy, I was hoping that you could jump in and explain some history about how this affected at least one known case, and I'm talking about Basali Moalen.
Right. So in response to the Snowden declarations, the government coughed up what it claimed was proof that this use had been really useful. And the one case that they at least claimed at the beginning had found a quote unquote terrorist they otherwise would not have found was a taxi driver named Basali Moalen from San Diego. And basically what they found was he was 2 hops off of a Somali warlord, and he had been trying to raise money for him. There's no allegation actually he was engaged in terrorism. There's a lot of reason to believe that he was just trying to fund an independent Somalia. Nevertheless, he was tried on material support charges and found guilty, and only then did he try and challenge his prosecution, arguing that he would not otherwise have been identified except for the use of this dragnet. That challenge was rejected by the judge. He appealed it to the Ninth Circuit. There was a hearing in 2016, and he still hasn't heard from the Ninth Circuit about whether or not he should get a new trial or whether or not his trial should be thrown out, because the identification of him dates back to that dragnet.
And Marcy, can you explain how Moalen and his defense team found out that they were subject to the dragnet?
Well, I mean, because the government, I think what you're getting at is One of the reasons Moalen is the only one who has been able to challenge the identification of him via this program is because, unlike, say, Section 702 or targeted FISA surveillance, defendants do not get notice of the use of 215 against them. So Moalen only got it because the government was trying to provide evidence that this was useful. No other defendants have gotten evidence. There's a couple of other defendants who have tried to argue that this was used against him. But basically, and I think Alex can address this, if you don't have standing, if you don't have a defendant who can point to a program, a surveillance use, some kind of abuse or what have you, then you're never going to be able to get, or rarely going to be able to get, some kind of ruling on whether or not the underlying authority, the underlying practice is legal or constitutional.
And I think, if somebody could correct me, Moalen only got notice about 215 through this rather complicated process of telling Congress after he was convicted. Is that correct?
That's right.
Yes.
Yeah.
Thank you, Alex.
And he didn't get formal notice in the way that a criminal defendant will get notice usually of surveillance against them. In the normal course, if you're surveilled under FISA, for example, under the more traditional provisions of FISA, and the government is prosecuting you in part on the basis of that evidence, the government is obligated to file a form in court notifying the court and the defendant that FISA surveillance in one form or another figured into the case. That's not what happened in Moalen's case, because his notice came effectively through public discussion and disclosures, not through a court filing.
And again, after he was convicted.
That's right. And the court allowed him to then raise his challenge, but as Marcy said, we've been waiting since November 2016 for a ruling.
Very quickly, we will have question and answer at the end. This is a very deep topic, so for the whole panel, we're going to try to keep it more accessible. But please just get ready to ask questions. There's a lot here. There's more than we can fit into an hour. We're happy to get to the stuff that is most important to you, and it's not always clear to us what that is. So now to kick it back to Alex, and we'll get to Sandy momentarily, but Alex, can you tell us about, let's say, the more appellate-style approach to Section 215 and your work there?
Yeah, so just a bit of background. As Marcy alluded, it is extraordinarily difficult to challenge any form of covert surveillance for the very reason that it is covert. And courts generally insist that people who raise challenges in court have what's called standing under the Constitution to raise their challenges, which generally requires that you be able to point to evidence that you were surveilled. And up until 2013, I think this is correct, not a single challenge to NSA surveillance that the government itself had not kind of affirmatively gone out and told somebody about had been allowed to proceed to the merits. The single most prominent challenge to that point was one that ended in the Supreme Court just a few months prior to the Snowden disclosures in, I think, February of 2013, in a case called Amnesty versus Clapper, in which the Supreme Court ruled on a 5-4 divide that the plaintiffs in that case, who were human rights organizations who worked in war-stricken regions of the world, included some of the defense attorneys for the Guantanamo detainees being tried in the commissions, that they didn't have standing to challenge Section 702, which was, at that time, still a relatively unknown but extraordinarily broad surveillance authority, because they didn't have specific evidence that their communications were being monitored. And that was the state of, kind of surveillance law on the eve of the Snowden disclosures. And for that reason, there was nobody to challenge Section 215 in open court. All of the litigation relating to Section 215 had taken place behind closed doors in front of the Foreign Intelligence Surveillance Court in non-adversarial proceedings, where the government goes to the court, presents an application, and asks for approval to conduct a certain form of surveillance. And even though that program relied on an extraordinarily broad interpretation of the word relevant, essentially the government argued and the court held, relevant means everything because once we get it into our database, we can query it for what we want. And so because we can query it for what we want in the end and get what's really relevant, assembling the entire database becomes relevant within the meaning of the statute. That interpretation, hadn't actually been codified in a real legal opinion of the Foreign Intelligence Surveillance Court. It had authorized the government's applications and issued orders approving them, but it didn't actually issue a detailed legal analysis of the Section 215 program until after the Snowden disclosures, when there was this very heightened focus on the FISC and its role in approving this program, and people wondering whether this system of secret judicial oversight was fundamentally flawed because it had produced this result that was so at odds with public understanding of what the statute could possibly mean. And so there wasn't a public ruling on Section 215. It ended up, the Snowden disclosures provided the basis for a public ruling. It turned out that the document that the reporters working with the Snowden disclosures first disclosed was an order from the Foreign Intelligence Surveillance Court directing Verizon Business Network Services, which is a subsidiary of Verizon, to turn over the records of its customers. And it so
Of all of its customers.
Of all of its customers. On an ongoing daily basis. And it was one of these every 90-day recurring orders. And it turned out that one of the customers of Verizon Business Network Services was the national office of the ACLU, where I worked at the time. And so all of a sudden, the ACLU, after we had lost this case in the Supreme Court, finally had standing to challenge Section 215 or any one of these NSA surveillance programs. And that set the stage for what became a case called ACLU versus Clapper, in which the Second Circuit ruled that the government's interpretation of Section 215 as authorizing bulk collection to support later querying was not, in fact, authorized by the statute, that was a misinterpretation of the word relevant within the meaning of the statute. And that ruling came out, I think it was May 7th of 2015, just a few weeks before the USA Freedom Act was enacted, which we'll get to, and it, I think, played a part in that legislative debate.
And I'm going to ask you to revisit that last point in a moment, but Sandy, can you, one, introduce yourself briefly, and two, why should we all be worried or not worried about surveillance of this nature, about mass surveillance?
Sure, thanks, Sean. Hi, I'm Sandy Fulton. I'm the Director of Government Relations at Free Press, which is a grassroots and policy shop. We work on broadband access issues and media ownership, and also privacy and surveillance, and net neutrality is one of our biggest campaigns. I think everyone should be concerned about surveillance, probably more concerned than we are at the moment. We should be thinking about the chilling effects it has on free speech and free association, just kind of intellectual curiosity, and just the kind of general erosion of our constitutional rights. A lot of these authorities were pushed through rather quickly after 9/11. Kind of notoriously, the PATRIOT Act wasn't read by a lot of people, and we should be revisiting these authorities.
And several members of Congress, I think, have said that they didn't read it before.
Right.
Yeah.
Yeah. I think I'm a little more concerned with who is being tracked and why. One of our colleagues, Alvaro Bedoya at Georgetown Law, often says we are all being watched, but not all of us are being watched equally. So I think when we see things like the Black Identity Extremists report being leaked from the FBI, and which is entirely unfounded, as well as like the DHS race paper, which is entirely redacted, there is evidence that law enforcement continues to focus disproportionately on people of color and activists in this country. That is incredibly concerning when we're talking about different levels of privacy and security that different people have in this country. We can look at how this administration has approached the Dreamers, calling them criminals, how they've cast suspicion on Muslim communities. And not that Obama was innocent of this with countering violent extremist programs, which were incredibly problematic as well. But this administration has been particularly aggressive. And with the HUPs that Alex has talked about, you can kind of see how these programs are built to track communities and track associations and track social movements. So yeah, I think that we need to be thinking about how this is being used and how that implicates our democracy.
Can I jump in too on that?
Yeah, please.
So I totally agree with Sandy. The burdens of surveillance have always fallen disproportionately on communities of color, and modern surveillance is not a novel example of it. It's just the latest example of that, not a novel thing. But that last point in particular, I want to kind of jump on because the Section 215 surveillance that we saw after 9/11 and other transitions in surveillance that we saw after 9/11 all reflect a shift in the way that the government goes about surveillance, a fairly fundamental one, and one that is not surprising in retrospect, given all of the advances that we've seen out of Silicon Valley over the last 15, 20 years. But it has been a shift from targeted surveillance to one of bulk surveillance. There's a lot of debate about what those terms kind of mean when you're talking about statutory language, but the shift generally is from collecting things about people to collecting everything, or as much as you can about everyone, to enable later forms of surveillance. And left unchecked, that transition will be very hard to reverse. There's been essentially a push within government, within the intelligence agencies, to shift all of the constraints on their surveillance authority away from limitations on collection and all toward limitations on use, with the idea that we can trust government to assemble enormous databases of information so long as we have the right set of back-end restrictions on the data that's being collected. I think that's a flawed approach to surveillance. I think it's one that enables abuse on a massive scale, and it inevitably happens. And I think we may talk about in a minute the fact that from the very first day that the Section 215 program went into effect in 2006, the government was not in compliance with the minimization procedures that had been imposed on it. And that was just one example of the violations that the government had been engaging in under its surveillance authorities of the PATRIOT Act and FISA.
Thank you. And actually, before we jump into, let's say, modern Section 215, that is the Section 215 post-USA Freedom Act, which is passed in 2015, Marcy, I know we've talked about that moment in 2006 where the Department of Justice is commenting on the law that was passed at that time, a reauthorization of 215. It made tweaks as well. And could you describe, or do you recall how DOJ described that shift, and then in turn what they did with it with the FISA court?
Sorry, can you ask the question again, Sean?
Sure. What did the DOJ say about the 2006 reauthorization bill, and specifically the insertion of the relevant to language?
Right.
And then
Right.
what did it actually mean going forward for the government?
So Congress in 2006 tried to narrow the application of what in 2001 had permitted the government to use these orders to collect anything pertaining to an investigation by saying that the collection had to be relevant to an investigation. And DOJ at the time said, this is a limiting language. This is meant, and we recognize that Congress means to impose some kind of limit on it. And yet at the same time, within weeks, basically, the FISC court adopted an earlier ruling about what it interpreted relevant to, and said relevant to can mean everything. So it's this moment where, it is particularly concerning because Congress had an intent, DOJ recognized the intent, and nevertheless DOJ then went to FISC in secret and said, never mind what Congress has said, we'd like to regard relevant to as, in fact, an expansive language rather than a limiting language.
And actually, Alex mentioned before 2006, the beginning of the bulk collection program, that is this chain of events. And so we should pull this up at some point. We'll figure out a way to provide it to all of you. But DOJ did. They made this a statement to the Congress saying relevant to will cut down on the number of people we can surveil. And then the FISA court said, yep, but you could also spy on everybody, which is important to keep in mind as members of Congress are writing these laws. All right, Marcy, back to you. What do we know about Section 215 since the USA Freedom Act passed?
Can I just jump back and make one more point about communities of color being targeted?
Sure.
So these are national security authorities. And so they are intended to have a nexus to a foreign country. They are generally, 215 is generally used for counterterrorism and for spying, to investigate spying. And with the argument that the government needs these authorities in an international context because they can't always open a criminal investigation. But think of the implications of that. It says that if the government is investigating Islamic terrorism, they can use this authority, and NSA can engage in this what remains massive collection. But if the FBI is investigating, say, right-wing white supremacist terrorism, they can't use the same authority. And it doesn't stop the FBI from being really successful at investigating right-wing terrorism. As we've seen arrests in the last week. But it does raise questions why the NSA gets to basically profile the Islamic community that may have ties to people overseas when it doesn't seem necessary given FBI success at chasing down purely domestic terrorism. So that's just to give you some kind of understanding. So in USA Freedom Act, what the government did was shut down the bulk collection of phone records. So they are no longer asking the major providers to send all of their records. Instead, what they're doing is they're asking the providers to send the records. They're asking the providers to do the 2 hops. The 2 hops remain in place.
And by 2 hops, you mean the target, the person talking, or the people's communicating with the target, and then the second hop is everybody communicating with that outer rung as well, right?
Right. So if I'm targeted, for example, NSA is going to go to the providers and say, give us all of the phone calls and texts and maybe, online texts that Marcy has been engaged in the last, both prospectively and historically and prospectively. They'll get that. Then they'll go back to their database and match up and find all of the identities of those people that they know. And then they'll go back to the providers and say, okay, give us all of these people's call records. So you're basically getting call records of people who never spoke to that original target.
Thank you. But back to the original question, what does Section 215 look like as implemented, post USA Freedom? And you and I have communicated about this, so I know it's extremely complicated. The simplest version you can. What are the big numbers? What does the big impact of this look like?
Okay, so there are 3 ways in which Section 215 is used. One is the NSA continues to use it, as I just said, this 2-hop dragnet that is used in a counterterrorism focus. So they have to go to the FISC first and say, this person, this target is associated with ISIS or is associated with Al-Qaeda or what have you. And they still collect massive amounts of records. The number that they collected in 2017 was 500 million individual call records. In addition, the FBI uses it in 2 different ways. One is targeted at individuals to do similar kind of thing. They don't get 2 hops, but anyone whom they're investigating as a potential spy and the people that are talking to a potential spy, they can get things like call records, internet records, bank records, mailing records, hotel records. So they can get a bunch of different kinds of data for people who are foreign powers suspected of being agents of a foreign power, meaning they're suspected of being spies, and those that they talk to. That's not 2 hops, but it does have impact on people who may not have any idea that the FBI thinks that they're talking to a spy. There's a third way that the FBI uses them, and this is an area of some concern that is not individualized, meaning they're not targeting an individual's device or an individual's account. And they may be targeting an address, so it could be a hotel or somebody's storage container. It could be an IP address. So it could be, for example, a suspected hacker who is using one particular IP address as command and control. But there's also another category of things where they have to go to the FISC and say, here's something else we want. And the FISC has to approve it. And that's where we don't know what's going on and where there are not enough, I think, protections against abuse. Right now, the protections are the FISC, the amicus, and any kind of providers who are being asked for information to push back. But in the hands of an administration that wanted to abuse it, I'm not sure that those are adequate. So to give you an idea, there were in 2017, there were 40 targets under the NSA program. So 40, and these targets could be, say, Al-Qaeda, with a list of a bunch of phone numbers that are associated with Al-Qaeda, meaning more than 40 entities. There were 52 of the second category, meaning individualized, used by the FBI, largely targeting spies. And then there were 25 of the third category that are not individualized, that, you know, again, probably largely targeting spies and hackers, but we don't know what that means. And
to wrap that up, so what we know from the transparency reporting, which in some cases was required by USA Freedom, so we know a little bit more now than we did before, that NSA program, which you may hear referred to as the Call Detail Records Program, produced over 500 million records in 2017. There's another 52 orders that seem to be targeted, but we don't know how many records they produced. And then this third category, 25 non-individualized ones, which we don't know what they were targeting, how they were targeting them, or how many records those produced. So we're starting at a floor, let's say, of 500 million and some concern about how many more might show up.
Is it worth explaining just very briefly what the statutory foundation is for this?
Absolutely.
It's enormously complicated, but there are a couple of key terms that might be worth knowing for people who are not familiar. So the key statutory change that Congress made in 2015 was to require the government, when it wanted to obtain an order requiring the disclosure of tangible things, or call records and the like, to go to the recipient of the order with what the statute calls a specific selection term. And it defines that. Thanks, Rashid. It defines that term in several different ways. And the reason why you have these different buckets that Marcy is talking about is because some of the ways in which it defines the term are more individualized. So a specific selection term can include an individual, like an individual, you know, their identity. It can include an account of theirs, so an account that they have, a device they have. It can include an address, which can be a physical address or an electronic one. But there's also a catch-all, which is where this third bucket comes from mostly, we think, that is any specific identifier. So a specific selection term can be any specific identifier. And then there's this other language that comes after that purports to limit this broad catch-all, but in a way that, you know, whose meaning is entirely obscure. It says, so long as the government is limiting to the greatest extent reasonably practicable, and I'm looking down at my notes here, the breadth of that term. But we don't know what that means. And that language sounds suspiciously similar to the language the government used to justify its interpretation of relevant under the original version of Section 215, in which the government argued it was not practicable to acquire a smaller set of data given its end goal of being able to query a very large set of data for terms associated with its targets. And so I think
And the FISA court signed off on that.
And the FISA court said that was an appropriate interpretation of the word relevant. Now we have the Second Circuit has a ruling saying that's inconsistent with our understanding of the word relevant. The FISC has since rejected the Second Circuit's interpretation of the word relevant in an opinion that came after the Second Circuit's ruling, in which the FISC was continuing to justify its original interpretation. And so it's unclear behind closed doors how the government has convinced the court, and the court has agreed, to interpret this kind of catch-all category of specific selection term, in particular, this language that purports to limit it in a way that seems, as I said, at best ambiguous and at worst suspiciously similar to the logic the government used the first time around to interpret these authorities very, very broadly.
Sandy, could you, there's another really important part of all of these laws that we've talked about, which is the sunset provision. And I'd love for you to just communicate what it means to you. What is that as an opportunity for Congress? What is that as a limiting factor?
Yeah, no, I think that's super important. During this year, as we approach the sunset, is to kind of consider what a sunset means. Like, we build sunsets into these laws because, like, these authorities are massive and they're invasive and their legality is questionable. But far too often, we kind of approach these surveillance debates with these kind of compromises and tweaks around the authority, and like that's how we come to the table. And I would caution Congress away from that. Like, actually, like we need to kind of have a more aggressive stance, like a more aggressive posture to like make the government prove that they need these programs, like that they are effective and that they are not being abused to target First Amendment protected rights and communities of color and activists. So yeah, I think that the sunset provision is important, and I'm some would argue, we have kind of been losing on the surveillance fight since Snowden. There's still massive collection going on under USA Freedom. So yes, I would ask Congress to take a more aggressive approach and ask the government to prove they need these authorities before they just, reauthorize them.
We're going to switch to a more open mode in a second, but I wanted to put a little bit of flesh on some of the things that you've all touched on. Marcy, I know you and I have spoken about CARE. Can you talk about, as briefly as possible, can you talk about how Section 215 might be relevant to an advocacy organization, an admittedly, politically oriented organization?
So in 2008, actually for a couple of years, I think, but until 2008, the executive director of CARE, which is the largest Muslim civil liberties, civil rights organization in this country, he was targeted on a individualized FISA warrant. We know that from Intercept's reporting Snowden documents. And at the time, the government, the FISC had approved as a default a 215 order on anyone who was already approved for an individualized warrant. And so what that meant is that that time in 2008, the NSA had the ability, and presumably did, to do this 2-degree, and actually it was 3 degrees at that point, to do this 2-degree contact chaining to understand who he was speaking with, who the executive director of the largest Muslim civil rights organization in the country. And what that would have given them is a map of the organization, of the organization's donors, and of the organization's clients. Because, say he spoke to their lawyers would be speaking to clients. And so you'd have all sorts of First Amendment concerns in that. And those people, based on, and Alex mentioned this earlier, those people, again, based on what the FISC approved at the time and what remains in place, those people become eligible for basically more invasive analytical scrutiny from NSA. So it's almost like an eligibility. There, back during COINTELPRO, there was a subversives list that Hoover kept. This sort of works the same, which is that if you're 2 degrees of separation from somebody of interest, then the NSA gets to look at you more closely than they get to look at somebody who isn't 2 degrees of separation. And we don't know how long those records would then be kept, whether those people will always be subject to that additional scrutiny from NSA. We don't know, Alex mentioned, we don't know the full extent of what those analytical processes at NSA are. CARE is actually a plaintiff in a lawsuit the EFF still has active. It's called First Unitarian Church, which has it also includes the NRA as a plaintiff. But that suit is interesting because they're asking for damages. And given that we think it's almost guaranteed that CARE was targeted by this approach, and by all rights probably still is, because they're probably still 2 degrees of separation from people of interest. They still represent people like, for example, the families of the San Bernardino bombers were represented by CARE. So they're 2 degrees of separation still. Then, it gives the government, it gives the NSA the power to map these organizations that the NSA wouldn't have if it were, for example, white supremacist terror.
To clarify one of the terms we've just been using, so CARE is the Council on Arab-Islamic Relations. Should have said that up front, but that's the largest American Islamic Relations. Thank you. That's why I didn't want to do it the first time. So we just talked about a bunch of different things that we don't know and didn't know. And I want to open it up to Sandy and Alex and Marcy, if you have more to add at the end. Before we invite questions from the audience, what questions should Congress, should people who are interested in this be asking and try to get answers to, let's say over the next 6 months or at least before December rolls around?
So there's still an extraordinary amount we don't know about Section 215 and the USA Freedom Act, which is surprising given the legislative fight that we had in 2014 and 15. So I guess I would say I'll sketch out a partial list. One thing we still don't know is the meaning of the key terms of the statute. We still don't know what specific selection term has been interpreted to mean at a broad level. We have these specific examples in the statute, but then we have that catch-all, and we have no idea how that catch-all has been interpreted. And relatedly, we don't know how that limiting language that comes after the catch-all has been interpreted. And that's a key provision of the statute, because when the fight was happening in 2014 and 15, there was a special focus on the question of, does the USA Freedom Act, in fact, end bulk collection? And that was the stated purpose of Congress at the time. That the title of the act, of the provision in the act that implements the specific selection term requirement is called something like ending bulk collection. But there were still questions that remained about whether the catch-all definition of specific selection term, along with this language that I discussed earlier, whether it in fact is effective at ending either bulk collection or very large-scale collection along the orders of magnitude that Marcy was talking about. Relatedly, we don't have the minimization procedures that the FBI uses in implementing this program. So minimization procedures under FISA, or really under any surveillance authority, are the procedures the government uses to minimize the invasiveness of its use of information after the fact. Usually they impose limits on, for example, how U.S. person information inside of an intercept or inside of some record that's acquired can be further disseminated. We don't have the minimization procedures that the government is required to submit to the FISC in support of its use of the USA Freedom Act. We don't have the minimization procedures that other agencies have in place to the extent they get access to these same records. We also don't know, as a general matter, the types of records that the government collects under Section 215. We have a broad sense of some categories, and Marcy has done extraordinary work in unearthing some of these disclosures and in piecing together what's out there. But it's one thing to suspect and another to have a real sense of the sorts of records the government is getting. And I'll say one final point, which is we don't know how the Supreme Court's decision in the Carpenter case has affected the government's surveillance under Section 215. Carpenter, as a reminder, is the case in which the Supreme Court held it is a search within the meaning of the Fourth Amendment for the government to collect 7 days or more of location information, of cell site location information. And people have generally interpreted that case to signal a shift in the Supreme Court's thinking about the third-party doctrine under which the government argues nobody has an expectation of privacy in records held about them by third parties, namely records held by our telecommunications providers, our email providers, tech companies, et cetera. There's reason to think that ruling should affect the way we think about surveillance as broad as what's taking place under 215 generally, and certainly very specific reason to think that it would affect any location information that is acquired under Section 215, and whether a large-scale collection of that information is constitutional. So we don't have any of that information, and it's very hard to have an informed debate about what reform should be put in place for 215 or whether 215 in fact should be reauthorized at all without having this basic information about how it's being used, with what protections meant to protect privacy, and with what consideration of recent major Supreme Court doctrine.
I'd let Marcy go next if she'd like.
Marcy, do you want to go first or last?
I can go ahead. One thing that hasn't come up yet is that in last year, roughly at the same time or just after the government disclosed that they had collected 500 million records the prior year under the CDR program, so the NSA program, they then revealed that they had been getting some records of some sort from some providers that was not permitted under the law. Just as an example, one possibility, the law explicitly prohibits them from getting location information. And there are ways, different kinds of technical ways that location information might have come in aside from being GPS location. In any case, the NSA destroyed all of the records that they had collected over the previous 2.5 years. That's great that they destroyed it, but we as the public don't yet know how it was allowed to go on for 2.5 years without being identified. Something that's always been a problem both at the FBI and the NSA side on this is they'll get stuff from providers that they're not supposed to get. And how they respond is actually something that's been a persistent problem. So we don't know how it was allowed to go on for 2.5 years without anyone noticing it. And we also don't know what it was that they collected. And those seem like both really important questions. One other thing that was actually a really good thing that came out of the USA Freedom Act was it included language that said the FISC should appoint an amicus for anything novel or noteworthy. And they had the ability to do that before, but it was basically the intent of Congress to say, you need to bring in an outsider to look at this. And there have been maybe 7 uses of the amicus since then. That's just a guess. But there has been at least one instance where an amicus should have been brought in. And this was actually not 215, but it was the 702 reauthorization in 2017. And the judge chose not to do it and chose not to give an explanation for why she didn't do it. It was Rosemary Collier, who's the presiding judge at FISC. So that raises questions whether the intent of Congress is being recognized on that issue. So a good question is, how many times has that happened? And then in last year's transparency report, so again, reporting on 2017, there were 3 applications of we don't know what sort, where the FISC said, this seems a little odd to us. We think that you should have an amicus review it. And the government said, oh, never mind. I'm just going to withdraw the application. Sometimes when that happens, the government then goes to the criminal context and gets a criminal subpoena or warrant or what have you, because they don't want the FISC to know what they're doing. And it would be, I think, really worthwhile to ask, what were those applications? And did those applications end up moving somewhere else? And were there instances from 2016 where that happened as well? So generally, how is the amicus working and how can it be improved? I think I may think of more, but go to Sandy.
Cool, thanks for that. So I'm not a lawyer, so I kind of let the specific questions up to the lawyers and Marcy. But I would just, again, just kind of reiterate, don't hesitate to ask all these questions. And without the answers to these questions, it is possible to let this authority sunset. When we write these, the USA Freedom Act and these other kind of reform bills, we trade off privacy safeguards to get a sunset so that we can revisit that. So I would just encourage your bosses to ask these hard questions. And if you do not get the answers, say you will not reauthorize that program. That it seems kind of nuts in Washington for some reason, from a grassroots perspective, which is what I represent. Free Press will be pushing that messaging. That's not unrealistic. We've been losing in this fight. We need to change the narrative around surveillance in this country. We need to change this conversation. We need to talk about who's being surveilled. We need to highlight those voices, and we need to push our champions to actually consider closing them down.
Thank you, all 3. I want to make sure that we get to questions from the audience, assuming there are some. So, does anybody have a question? Yes, please.
Yeah, the question related to the NSA collecting the data. So, you said NSA was collecting the data of the call history. Was it also including the content that was discussed during the phone calls, or was it only that this person talked to the other and the contact information? And also, since the technology is developing, is NSA going to be also able to collect data of social media? For example, they can use using the phone providers or just internet providers to get access to information in social media that should not be public.
I'm going to route that to Alex.
So on the first question, under this program, no content was collected. This is the call detail records program was just about call detail records, which are the metadata of the call. Who was calling whom, when, how long they spoke, and at least at one point, during the program, they were collecting what are called trunk identifiers of phone calls, which reveal broad geographic information. To your second question, absolutely. There's nothing that would limit the government's use of USA Freedom to collect social media kind of contact information. The definition of specific selection term includes an account. Your Twitter handle is an account on Twitter, and that could be used as the basis for forcing Twitter to turn over your records on Twitter, your contact records on Twitter, and in some cases maybe even the contacts of your contacts.
Alex, if I can, I kind of want to.
Can I jump in on that too?
Sure, go for it, Marcy.
Yeah. So the definition of a call detail record, which is the NSA program, is a session identifier. So it doesn't, and this is another thing that I think should be asked, how they interpret session identifier, because as that question, I think, rightly noted, a session identifier could be me using my phone to use Signal, to get on Twitter, to get on Facebook, to get on WhatsApp, to get on, and so we don't know. The definition of the providers is also a little bit squishy. I mean, it's phone companies. Apple is a phone company, so could they go to Apple and say, we want iCloud content or iCloud metadata? But we also don't know at what level. I mean, Verizon has a ton of information, for example, of what I do on their phone, aside from sending texts and making calls with my Verizon phone. So are they getting that data as well? One other thing that's important to know on the NSA program is the NSA, before it sends out its requests to providers, first goes into its own stores of data, which is called EO 12333, which is stuff they've collected overseas. A ton of internet stuff they can collect overseas because that's the way the internet works. So what they'll do is say they want to chain on me. They think I'm an international terrorist. The first thing they'll do is they'll go let's see all of the phones that Marcy uses and all of the things that we think phone companies have on Marcy Wheeler. So they might, for example, find a burner phone of mine that they've identified, because I use it when I fly to Europe. And then they'll go to providers and give not just my main phone call, my main Verizon number, but they'll give, the burner phone that I use when I'm in Europe. And so they're actually, what they're trying to do, what NSA is trying to do is to fill in the gaps on this even larger dragnet that they collect overseas with domestically collected information. And some of the stuff that they collect overseas is stuff that pertains to domestic practices, because again, you can collect internet metadata in many different ways and in many different locations. So hope that adds to the answer.
And maybe just to state the obvious too, metadata often reveals content. If you call the ACLU or the NRA or an abortion clinic or what have you, the content of that call would not show up under the NSA version of the USA Freedom Act program, but a lot about the call would have been revealed by the metadata.
And so, and I'm going to go to Alex on this. We've talked about the two hops, and so they start with numbers, identifiers that they want to chain down, to put a little bit of flesh on some of the terms that Marcy's been using. So we start with phone number, every contact point that it's ever had, and then every contact point there. But I think what Marcy just said is that this first step isn't really just one number, right? It's the pool of available identifiers for the target.
That's right. Yeah.
And so how big might that pool be? Right? The people in this room, how many identifiers would be in that starting pool?
Depending on the person, conceivably hundreds. Certainly dozens. Every account that you use, every device that you use has a unique identifier associated with it.
For instance.
Yeah, so all your social media handles, your laptop, for example, you may not know this, probably has about a half a dozen unique identifiers associated with it, including the one that uniquely identifies your Wi-Fi card, or the one that uniquely identifies the LAN connection if you still have one. All of those could be unique identifiers. Just to double down on a point that Marcy made earlier about Executive Order 12333, that is the ice beneath sea level. Is that the right term? That's the iceberg. Under the underwater part of the iceberg. By far, the most information the NSA acquires is through Executive Order 12333, and they consult their databases of data acquired under extraordinarily permissive standards under that authority at each of these, the first two steps of the call detail records program, when they're first coming up with a list of identifiers for their targets, and then when they're secondarily coming up with a list of identifiers for their targets' contacts, who they are then using to reseed the request to the telecom provider. And we have very little information about how many of those identifiers the NSA is using when it's making these requests to the telecom providers.
And maybe it's baked into the name here, but did Congress give the executive branch any power to conduct operations under Executive Order 12333?
No. And it's obviously, it's a Reagan-era executive order. It actually guides all of the intelligence agencies' authorities, but it is most pertinent outside the country where there are not other constraints on the government like statutory or constitutional law. During the last fight over 702 reauthorization and USA Freedom, it became pretty apparent that there has been little intelligence committee oversight of NSA surveillance under 12333. It is it's the kind of wild west of NSA surveillance, and anything you can imagine that could take place technologically may very well be taking place technologically under that program if you can think of it as being useful for the NSA to do. Bulk collection on steroids is how I think about it.
Do we have other questions? Sandy? I am curious, as somebody who spends a lot of time on the Hill, let's talk about the committees of jurisdiction, right? They're, in many contexts, resources for members who are not in committee. Would you describe, who would you say that these people should talk to if they wanted to talk to committee staff, right? What committees are their allies on this? What committees are looking at it seriously? I only mention this because Alex flagged that the intelligence committees, you said, weren't necessarily interrogating these issues as closely as we have been today. And so, Sandy, do you have anything to add there about, from your experience working with all of these?
I think we generally focus on the Judiciary Committee, which I think has a lot of great champions on it. I think there are a lot of voices on the subcommittee of jurisdiction that we could be highlighting, particularly around like Karen Bass or Cedric Richmond or Cicilline. I mean, these are kind of folks that have been strong on the issue, and we need to continue to push.
But the intelligence committees are.
This committee is not as friendly towards the issue. Yeah. And then also, I would say we should be talking to the Progressive Caucus and the Black Caucus and folks around those committees to talk about, again, the disparate impact of these programs.
Could you actually, come to think of it, could you speak to leadership, right? So, was Paul Ryan good on this? Is Speaker Pelosi good on this? Who are you hoping will lead the charge in talking about this and interrogating the issue moving forward?
I think that, yes, I think that some of our kind of more libertarian-leaning Republicans have been quite good at this. Representative Amash is a great champion on this issue. The Democratic leadership, I don't think, has been as strong, sadly, and I think that those are folks that we need to be pushing.
Thank you. Does anybody else have any other questions, or if not, I'm going to kick it back to the panel for any last thoughts. I'm going to go with the last thoughts then. Marcy, why don't you start, and then we'll go to Sandy, and then we'll go to Alex.
I'm just going to throw out some things that can be done with a reauthorization that would improve this. One is more transparency. I think that there are holes. We've seen there are holes in the transparency procedures put in place with USA Freedom Act. I think we can fix those. I talked about shoring up amicus. I think this is a good opportunity to do that. It would be a pipe dream, but it would be worthwhile to try and get notice of the use of 215 to defendants so that we can identify downstream if certain communities are being targeted. And I think that we should aim at least to codify two things. One is that relevant to is in fact narrowed. And one way to track that is to require reporting on how much of those non-individualized returns come in. And then the other thing is, it is unclear from the law whether this big collection of data the NSA gets, whether that's shared with CIA or FBI. And I've heard claims that it's not. If it's not, and it doesn't need to be, then that should be codified as well, because it then takes that huge amount of data outside of the hands of law enforcement that can actually go arrest people. So those are some things that I think could be improved with Section 215 and should be improved with reauthorization this year.
I feel like I'm kind of just repeating myself. I feel like things like notice and transparency and reporting are all great, and those are all things we'd love to see in a crazy strong reform bill. But short of that, I think that we need to be really talking about surveillance in a way that we have not done in the past number of years. There seems to be a lot of energy around consumer privacy right now, but still not so much around government surveillance. So I think that we need to be pushing back on this narrative and talking about, like, what does the government actually need?
And Alex, can you close us out?
Sure. I just want to maybe kind of repeat something that Sandy said toward the beginning, which we haven't talked about since, but I think is a really essential point. We haven't had the same conversation around effectiveness about USA Freedom that we had around the bulk collection program that ended in 2015. One of the, I think, critical data points in that reform debate was the fact that the PCLOB, the Privacy and Civil Liberties Oversight Board, as well as the President's Review Group, had both analyzed the bulk collection program revealed in 2013 and concluded that the program wasn't effective in the way that the NSA claimed it was, or not needed in the way that the NSA claimed it was, at detecting the bad actors they wanted to detect. We should be asking those same questions about 215 as currently constituted. Is the authority as broad as it is now necessary? Do we need the kind of ambiguous possible loopholes in the statute for the NSA to be able to accomplish what it wants to accomplish, or are those just, to use the trite phrase, loaded guns laying in wait for somebody to misuse? We should have that debate about effectiveness. I think that would be an important part of the reform debate.
Thank you. Thank you, everybody, so much for joining us. All three of us, and less so Marcy, will be here for the next 15 minutes. I'm going to probably disconnect her, which suddenly sounds like a very scary activity. But thank you very much, Marcy. Give you a quick wave.
Thank you.
And thank you all for joining.